Welcome to Published, a podcast by Greenleaf Book Group, where we'll discuss the ins and outs of the publishing industry, from writing a book and finding the right publisher to gearing up for a book launch. And now, here's your host, Greenleaf Book Group CEO, Tanya Hall.
If you've been following the growing tension between authors and artificial intelligence companies, you may have heard rumblings about the Bart's versus Anthropic class action lawsuit. This case is one of the latest and biggest copyright battles in the AI world. Anthropic is the company behind Claude, one of the major generative AI models. A group of authors, including Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, sued Anthropic, claiming the company used their books without permission to train its AI systems. They alleged that Anthropic had copied thousands of copyrighted works, many obtained from online piracy sites, to help Claude learn how to write and summarize text. In September 2025, the case reached a proposed $1.5 billion settlement. Anthropic hasn't admitted wrongdoing, but it agreed to the payout to resolve the class action and avoid years of litigation. The settlement will compensate authors whose works were used without legally being purchased or licensed, including roughly 465,000 titles. It also sets a major precedent for how creative work will be valued and licensed in the AI era. Unfortunately, some authors who had their work misappropriated by Anthropic are not eligible for the settlement because their copyright was not properly registered. Others are eligible, but will have to split their settlement with their publisher. This is likely the first of many cases related to copyright infringement and AI, and in late October of 2025, OpenAI lost a bid to dismiss authors' claims that text generated by ChatGPT infringes their copyrights. So today we're unpacking what all of this means for authors and for the future of creative ownership. We'll also discuss how authors can protect their work moving forward. Now let's dive into the interview.
So to start off, I know you've been following the Anthropic case closely as it's unfolded. What were your initial thoughts when you heard about the class action lawsuit? Was this something that you have been expecting?
Yes, I think all of us were expecting something like this at some time. Much of our copyright law comes to evolve by virtue of legislation and lawsuits. So it was really just a matter of time before something like this happened so that our laws could catch up with the very quickly changing world of AI. And I think it's been very clear to a lot of people that content has been used in this way. So I think some people were quite relieved to see this lawsuit come through.
Mm-hmm. It's something that seemed kind of glossed over in conversations I've seen about this case is that the settlement is only related to how Anthropic gained access to the book it used. So my understanding is that for the books they bought legally, using them to train Claude was considered fair use. How do you feel about that fair use will cover using copyrighted work as an input for LLMs?
Yeah, that is probably the most controversial and maybe misunderstood thing about this entire case. So let me back up a little bit. For people who aren't familiar with it, I think there's a common misunderstanding that this is actually a landmark settlement case, yes, around proper remuneration for an author's infringed work. And it's not really. So if you actually break down the case, to your point, the district court said that this use, so they scraped these books and fed this content into their language learning model to train it. The court said that that was a legitimate transformative fair use. So the word transformative there is key, meaning the difference between, let's say they grabbed 3 chapters of my book and just spit them out verbatim in response to somebody's prompt. Well, that would be outright copyright infringement. But to take my work and other people's work and synthesize that, and then the AI machine comes up with its own output that's different, that's a transformative work. So under the law, or at least that interpretation of the law, that was allowed. The actual infringement, like you said, is how they obtained the work, which was through pirate websites. So you can't just go scrape something and not obtain it in the legal way, because it is illegal to download books off these pirate websites. And that's actually what this case is dealing with as far as the settlement goes.
And so from what I've seen, Anthropic has agreed to pay a total of $1.5 billion, which means impacted authors who their work was scraped and their work was obtained through those plagiarism sites, they may receive around $3,000 per eligible title. Do you have any thoughts on the settlement amount?
I think we all have lots of thoughts. So, and honestly, it's really complicated because under federal copyright law, if your work is infringed, this is the phrase that gets thrown around a lot, you can be eligible for up to $150,000 per infringement. But that's a scale, right? So you would have to be pretty egregiously infringed to be on that 150,000. Like somebody would have to literally take your work and pass it off as their own versus this, which is already arguably fair use according to the court. I actually think the $3,000 settlement is a good thing in terms of it's setting a precedent that for copyright holders, this is enforceable and you have to do things right. Even if it is arguably fair use, you have to obtain them through proper channels, which in theory should involve the publisher in some licensing or some type of compensation. So that's good. The other argument is that while $1.5 billion is a huge amount of money and certainly the largest copyright settlement ever, it is a drop in the bucket for a company like Anthropic. So are we in a scenario kind of like when the EPA says, don't run your factories at night or you'll get a fine of $3,000. And the company says, yes, but we make $300,000 when we run our factories at night. So we'll do it anyway. Are we in that kind of a dynamic just due to the sheer size of this company? So there's a lot of these kind of open questions being thrown around right now. Just in my experience and based on the feedback that I'm getting from a lot of the authors who were impacted, they're actually quite grateful to get the $3,000 because had this gone all the way to court, again, there was no guarantee that it would even survive basically the proceedings since that whole fair use question is still such a gray area.
That makes a lot of sense. And your book, Ideas, Influence, and Income, was one of the books that was scraped to train Claude. Did you have any reaction to learning that?
I had a little flurry of reactions at first. I was surprised. And then I was really proud for a second. I was like, yes, it chose my book to learn all about publishing. And then I realized that it took millions and millions of books. So there really was no vetting. It was just arms wide open, grab all the stuff you can. So ultimately, then I kind of came around to feeling somewhat violated. Like, well, yeah, if they had properly licensed it from me, would I have made more money? Honestly, probably not. Like $3,000. Just when what I know about licensing things like foreign rights, again, we don't have a benchmark for licensing things for AI learning, but for other types of rights deals, that's in the neighborhood. So it was interesting because at least it allowed me to sympathize with the other authors who are in this settlement class versus just looking at it from the outside.
Right. And were there any other Greenleaf books that were included in the settlement?
Hundreds. Yeah, hundreds of them. So that was the other interesting thing. And for anybody who's wondering if they're impacted, if you go to anthropiccopyrightsettlement.com, there is a very robust FAQ and a works lookup tool. So you can go in there and pop in your ISBN or your title or your author name, and it will tell you if you're in the settlement class. And yes, we had hundreds of books in that class. So that was also surprising because it wasn't just nonfiction surprising. It was fiction, it was children's books, it was all kinds of things that I was somewhat surprised to see in there.
What was the process that you went through in helping out the authors who were impacted?
To actually properly submit a claim for the settlement class. It's a little bit complicated, and for Greenleaf authors who are the sole owners of their rights, they have to choose a couple of default and not default options. So this is the other reason it was kind of good that my book was in there. I went through the process myself, saw how the form was laid out, and realized, okay, I actually have to substantiate that I'm the sole owner of my work, which meant I needed to upload my contract. And then I realized every Greenleaf author who's in this class is going to have to do the same thing. So we went through and pulled what information we could out of the works lookup database, grabbed the author's copyright number, which they will need to show that they properly registered their work with the Copyright Office, and then grabbed their contracts out of our files and sent all of the information to each impacted author to say, hey, you're in this settlement group. Here's everything you need. Here's exactly how to go through the form and submit your claim, just to make it an easy lift for them.
I have heard a couple sticky situations some authors outside of Greenleaf, just authors in general, are running into with making their claims. Can you explain why some authors might not be eligible for a settlement payment or why they may not keep their full payment?
Yes, that's interesting because, as I mentioned earlier, millions of books were actually downloaded from these pirate websites. The criteria to be in a settlement class, the book has to have an ISBN, and you'd be surprised many don't. If you're doing something like self-publishing through KDP, you may not have an ISBN. So you have to have an ISBN. The book has to have a proper copyright registration, of course. Then there's some other little indicators like, is it educational or not? So by the time that criteria is applied against the millions of books that were scraped, the actual number of impacted works in the settlement class dropped to just under 500,000. So the other thing that's important here is the book has to have a proper copyright registration with the Copyright Office. And that's something that I think people, even in the publishing industry, are frequently miseducated about, because there's the concept of the poor man's copyright registration where you mail your book to yourself and it's copyright protected. You don't have to do that. you have copyright protection once the book is in tangible form. So just by virtue of authoring it. Now, you can't enforce that protection, however, until you register it with the Copyright Office. And that gives you an actual copyright number, and you will show up in their database of copyrighted works. So that's where I think people don't understand the importance of taking that extra step to do the proper registration, because yes, you are protected in the legal sense, like it's yours. You can say, hey, that's mine, and you violated it, but you only get access to the recourse as outlined in federal copyright law or eligibility for this type of settlement claim if you've registered it with the Copyright Office. And a lot of people, even publishers, have skipped that step.
So what do you feel is a publisher's responsibility in protecting an author's work?
So technically that comes down to the contract, of course, and who's doing what according to those terms. But I think coming from a place of stewardship and just philosophically, publishers know so much more about this, or they should, than the general author. So our business model places a strong emphasis on the ownership of rights. So we're especially attuned to it. And that's why we're very proactive in cases like this where our authors' rights have been violated. So I think it really does come down to the letter of the agreement, but I would like to think that publishers would understand that copyright is important, and to make sure that an author who doesn't know how all this works has at least the tools to educate themselves, if you're not educating for them, would be their responsibility in my mind.
So you mentioned that even sometimes publishers don't register them or they haven't been registered properly. Is there a way that an author can verify that their work has been properly registered, even if they are registering for it themselves?
Yes, if you go to copyright.gov, there is a lookup tool there. And it's not the easiest tool to use, but you can put in the title of your book and it has just, millions of records, but you'll have to kind of whittle it down by the date, the time frame that it was published, and then you can find it. If you actually go through the process yourself of submitting for copyright, you'll get a certificate back, like a digital certificate, and that will have the number that you need, and you should tuck that away in your records. You probably won't ever need it, but in a case like this, you might need it. Even if you don't have that, you can always find it again on copyright.gov.
That's great to know. Another common question for authors is whether they need to copyright their manuscript before they begin submitting it around to publishers and agents. Do you think it's a reasonable step for an author to take to protect their work during the submissions process, or should that come further down the line once the book is actually being published?
That should be further down the line. The standard rule of thumb is you submit it for copyright registration within a 3-month window of it being published, because you want to copyright the final form. And there's probably still a lot of changes and revisions that it's going to go through once you sign on with the publisher. It won't be final yet. So if you're nervous about that kind of thing, you can have your publisher give you an NDA. And then at least there's some protection around disclosing the material. Your publisher is not likely to be the one to encroach upon your copyright. I have authors sometimes who have a little freak out about that, and they say, "Oh, I don't want to send my book in because the publisher could just like plagiarize it, copy the whole thing, and attribute it to someone else." And it's almost comical. That's why I'm giggling to us, because we know that so much of the book's success depends upon an author being out there and talking about the book and promoting it and being one almost with the content. And so that just the concept of that makes no sense. But anyways, I understand the concern, and NDA should protect you in that regard. Just make sure that there's either, if you're not doing it, that the publisher has a commitment to register the copyright within 3 months of the book being released.
And you spoke earlier about how the publisher's responsibility, it comes down ultimately to what's in the contract. Are there any specific clauses or protections that you think every publishing contract should include, particularly in the AI era?
Well, I think it really comes down to an author's priorities individually. So, if you are dead set against having AI train on your content, then it would make sense to put something on the copyright page that expressly prohibits AI training without written consent. And that way, at least you're making it very clear what the expectations are. And it gives you maybe some protection down the road. If there is a violation, you can point directly to that and say, it's pretty clear that I said you can't do this right within the book itself. And then contractually, it's probably smart to have a reservation of rights clause that basically says any rights not listed or not known are excluded from this contract. So that, it's wild to think that 10 years ago, we wouldn't know to have a clause about AI learning in our publishing contracts. That's how quickly it's changed, despite our industry generally moving really slowly. The same thing happened back when ebooks became a thing. And there was some confusion about, well, do publishers who have these old kind of backlist contracts for titles before ebooks were a thing, do they have the right to produce an ebook now? So that came down to whether there was language in there protecting the author against forms not yet known, in which case the publisher would have to go back and give some extra compensation for this new format. So it does come up. It feels like very almost sci-fi to think that there are going to be formats that we don't know about, but there's two examples in the past couple of decades.
Wow, that is so interesting. Against forms not yet known.
Mm-hmm.
So does adding that language to the copyright page saying that your book can't be used by LLMs, would that protect? Is that enforced?
I'm going to go out on a limb and say no. I don't think it's not an enforcement tool. It's more of a down the road, should you have to litigate, unfortunately, or send a cease and desist. It's more of a protection tool and defense, right? You're playing defense to say, you must take it down because I explicitly stated you can't use it, versus some argument against fair use. And they can probably still argue fair use. So I think it's more, again, just a protection. It's not so much how do you enforce AI, right? It's a pretty big machine. So there may come a time where there's a way to do that, but we're kind of in the Wild West right now, and we're not there yet.
Right. And speaking of, regarding how Anthropic originally obtained this data set, this massive books, was there anything that could have been done by these books, by the copyright owners, to have prevented their book being included in the data set?
That's a great question, and one I'm surprised I haven't heard more from our authors. The answer, unfortunately, is no. So the two sites that Anthropic took content from are LibGen and Pirate Library Mirror. I keep mixing up those last two words, Pirate Library Mirror. And these are sites that obtain content illegally. So every ebook that's produced, to go down a little bit of a rabbit hole here, has what's called a DRM wrapper on it, and that's digital rights management. And that DRM wrapper is intended to prohibit things like this from somebody like basically breaking the downloadable file, grabbing the content and reposting it. But technology is such that somebody will find a way to break that DRM wrapper and post this content illegally for someone to scrape. Now you're wondering, why don't they just take down these sites? These sites, hence the word mirror, have multiple mirrors of the site in other locations. So you could go after one version of the site and then, 10, 15 more of it will pop right up. They're generally anonymous, they're decentralized, and they're often outside of US jurisdictions. So very difficult to police, and they've kind of just become a known pest in our industry. So it's interesting when you go into the works lookup and on the Anthropic copyright settlement page, there, the fact that Random House has like tens of thousands of titles in there tells you, okay, it's not a matter of someone didn't do a good job with the DRM wrapper on their ebook. It's just unfortunately speaks to how common of an issue this is.
So for authors who are worried about AI using their work without permission, or they discover that their work has been used without their permission, what can they do now to protect themselves or in response to finding out that their copyright has been violated?
Yeah, a few different things, and it depends, of course, on the severity. The first thing, of course, would be ensure that you've got that copyright registered, so you have access and recourse under the federal copyright law. Then often it starts with a cease and desist letter. That's sometimes enough to get the violating party to withdraw, if that's possible, whatever they've used. If they've posted, let's say, something on on their website that belongs to you. So that's one thing you can do. If it's online, there's something called a DMCA takedown notice. That's Digital Millennium Copyright Act. We see this a lot you'll see a workbook version of a popular book that's unauthorized, and it's someone used AI to do a summary of a book that's selling well, and it's arguably fair use, but really it isn't. So generally we'll issue a DMCA takedown notice on something like that. You could submit a DMCA takedown notice as well for sites like LibGen and the Pirate Library Mirror. Whether they actually respond to it, again, if they're anonymous and kind of, these under the radar, dark web kind of sites are probably not really interested in abiding by the law, but at least you go through these steps to try and cover your bases before you take it any further. And then if you had to sue, you can, of course, sue in federal court. This is a federal copyright violation. So there is a copyright claims review board that you would start with first for smaller claims. And then for larger claims, you would want to get a lawyer and go through the process of actually trying to be compensated to the fullest extent of the law.
Something else that I've seen recently has been books that are uploaded to Amazon impersonating the author, that the author has written them. They maybe aren't directly infringing copyright, but for example, this has happened. Jane Friedman has talked about this, that there have been books uploaded as if they've been written by her with her credited on them, but she did not write them. Does that also land under copyright infringement?
It's not copyright so much as if Jane had a trademark on her own name, she might have some legal recourse. So trademarks are different than copyright, and then they typically deal with brand elements, logos, slogans, taglines, titles. In some cases, it's very hard to get any you can't copyright the title of a book, but in some cases you could trademark it if it was part of like a larger brand. So in that case, she might have had some recourse, but I remember reading about that when it was happening. It was very interesting. That's pretty difficult to police. And you would start again with the DMCA takedown notice, see how far you can get, and would probably have to resort to significant legal investment to try and put a stop to that. It's really unfortunate.
Can you explain a little bit more about what the compliance process looks like for trademark registration?
Trademark registration goes through the trademark office versus the copyright office, and it can be somewhat complicated because the trademark office wants to make sure that there is no confusion about which industries or sectors your trademark is applicable. So for instance, you might have Greenleaf Lawn Services, and you can have Greenleaf Book Group, and those trademarks aren't confusing to the general consumer, so they can coexist. It's basically when there's something that could cause creation, that you have a potential conflict, the trademark office will closely inspect for that type of potential conflict and also evidence that you actually are doing business and not just trying to like stake a claim on something you want to do down the road. So trademarks are harder to come by typically, again, because you have to show use. So you have to be out there using a slogan or a tagline in your brochures. Like we recently trademarked ideas, influence, and income. And we first had to demonstrate that we were using it throughout the website, not that it was just on my book. That wasn't enough. So they were actually using it as a framework for some sort of education and using it as a tagline on the website and like just more of kind of a holistic, more integrated use that deserves protection versus just it's the name of my book and I don't want anyone else touching it.
Interesting. So do you think that the average author should be thinking about trademark registration as well as their copyright registration?
Honestly, the average author probably won't be able to, because to trademark the title, even like a series name of a book, it would have to be part of a larger program. I'm thinking of like some of the Rich Dad, Poor Dad type series where there is a workshop and there's a franchise train the trainer program. There might be other media content. Like that's probably going to qualify for a trademark. But for your typical author who's doing one book that has a title that kind of connects to their business, it's expensive to try and get that through. And you're probably going to have a tough case to prove unless you've got a pretty robust use case behind the trademark. So it's really more important to focus on the copyright. So you're protected against people outright taking the thing that you authored. And then if later on there's a brand violation, that's a lot less, I think, common than outright someone plagiarizing your work or taking entire frameworks out of your book, as sometimes is the case with nonfiction authors, and then ripping them off and using them in another book. That's, again, the trademark stuff is probably less of a concern for most authors.
Okay, this is so much information. I'm sure that people listening, their heads are spinning. Do you have any parting thoughts, any things you really want to make sure that authors walk away with?
Again, I think I really want to underscore the importance of making sure that your book is registered with the Copyright Office so you do have full recourse if there is some sort of an infringement. Also, in my book, Ideas, Influence, and Income, there is an entire section about protecting your work. And we, as you know, Mads, are in the process of updating that book now to talk about AI and some other scams. But it does go into the difference between trademark and copyright and how to think about those and when you need to be concerned. So if somebody's listening and was a little hung up on that section, then please go to that part of my book. We do address that in some length. And then finally, the Authors Guild is a great resource if you're concerned about infringement on your rights, or you're looking for maybe some help with wording for contract phrasing to address these AI concerns. The Authors Guild has been very involved with the Anthropic settlement litigation and has a voice kind of in how those proceedings are going forward. So they have a lot of tools and resources to help authors protect themselves as well.
Great. Thank you so much, Tanya. This has been absolutely enlightening.
You are welcome. I also want to say I'm not a lawyer.
Yes, but really great resources for authors, I think.
Absolutely. Happy to help. That's all for today's episode of Published. It's our goal to empower and educate authors, and we hope this reflection on the Bartz versus Anthropic case has been informative. For any currently published authors, you can visit anthropiccopyrightsettlement.com to learn more about the case's status and whether you are a class member eligible for the settlement. They have a searchable database you can use to look up any books you've released and see if your book's data was scraped. Claims can be submitted anytime before March 23, 2026. For a transcript of this episode and additional links, visit greenleafbookgroup.com/episode 101. A big thank you to Madison Johnson, who produces the Published podcast. You can also find advice for writing, publishing, and promoting your work in my book, which you can learn more about at ideasinfluenceandincome.com.